Hey, good morning. Time is 9:30. I guess we should start, despite not everyone is here, but it's okay. Okay, so ladies and gentlemen, as a quick recap of what we've been doing, just to make sure that all of us are still on the same page, understanding what we're doing. Uh, we just scroll this up a little bit. So yesterday we started on the chapter on parliamentary supremacy, right? We went into the historical reasons why Parliament is supreme. Uh, primarily the very quick and easy reason is because there is no written constitution. And when there's no written constitution, something has to take its place at the top of the pyramid of power, isn't it, right? The pyramid of power, there cannot be a void at the top. There cannot be a void at the top. So there must be something there, and Parliament has taken over. But we also went into the sort of historical reasons as to why Parliament took over, the war between the king and Parliament, and so on and so forth, so that we have a contextual understanding. How is it that Parliament became supreme? Then also we understood, or we tried to understand that this concept of parliamentary supremacy is not one that is written down anywhere. There's no higher act that says Parliament is supreme. The reason why Parliament is supreme in the UK is the recognition that the judiciary gives that Parliament is supreme, right? So the entire basis of parliamentary supremacy rests on this recognition that is given by the judiciary, right? And legal philosophers have stated that judicial recognition is something that is absolutely important, right? It's called the rule of recognition, right? This is propounded by great authors and thinkers like Hart, H-A-R-T, Hart, and people like him. So once we understood that, then you went into, okay, so fine. So we understood the concept of parliamentary supremacy already. What then is it? So when I say parliamentary supremacy, what does it mean? Then we went into Dicey's definition of parliamentary supremacy, or a lot of books will use the word illustration of parliamentary supremacy. Then we saw Dicey's 3 illustrations of parliamentary supremacy. So this is effectively his description of what parliamentary supremacy means. And unlike the rule of law, right? Unlike the rule of law, this understanding of his description of parliamentary supremacy is universally accepted, right? It is the only description, and it is widely accepted, right? So according to him, parliamentary supremacy means Parliament can make or unmake any law, number one. No one can question the validity of an act of Parliament. No one, including the courts, right? No one can question the validity of an act of Parliament. And number 3, Parliament cannot bind its successors, nor can Parliament be bound by its predecessors, right? So Parliament cannot bind its successors, nor can Parliament be bound by its predecessors. Okay, very good. It is this definition that we are going to be measuring everything that comes after that. Because the rest of the chapter is effectively about, is Parliament still supreme? Right? Is Parliament still supreme, either in light of the general, generally, the judiciary, do they recognize Parliament as supreme? And that's what we looked at yesterday, right? We looked at many cases. It seems like there are some judges that are suggesting that parliamentary supremacy is no longer relevant. Parliamentary supremacy is dead. Sometimes they expressly say those words, but sometimes by their conduct of when an act of Parliament is absolutely clear, they don't follow that act of Parliament. They interpret it to mean something else, totally different. So there are a lot of allegations that perhaps maybe Parliament is no longer supreme. So we went into that yesterday. We looked at the various judges and all that. Then after that, we started on the specific challenges. So what we did earlier was the general challenges. Then we started looking at the specific challenges. So the specific challenges, there are, like I said, about 6 challenges to the doctrine of parliamentary supremacy. And we are going to go through them one by one. We have already gone through 3, right? Section 4 of the Statute of Westminster. What was our conclusion? Our conclusion was it is not a real challenge to parliamentary supremacy. Then we looked at the Acts of Union, right? The Acts of Union with Scotland and the Act of Union with Ireland. We looked at that. Then we also understood it. We must first understand why it's a challenge. So this is the important thing. You must be able to understand why people say it's a challenge. And then you can argue, well, no, it's not really a challenge, right? Then we did the Sewell Convention, right? We've also done the Sewell Convention already. And then when we discussed the Sewell Convention, we also came to the conclusion that perhaps it is not a real challenge to parliamentary supremacy. So today, ladies and gentlemen, we're starting with number 4, the manner and form argument, right? I just want to tell you that number 5, devolution, we are not going to do because the university has said that devolution as one of the challenges to parliamentary supremacy is no longer in the syllabus. So you can safely mark out devolution, and we're not going to do it. There's a good reason for it. There's a whole chapter on devolution later. Right? There's a whole chapter on devolution. So I think the university felt that it was a lot of overlap and unnecessary overlap in the syllabus, right? So this devolution part is no longer, you don't have to worry about devolution. If an exam question asks you specifically about the challenges to parliamentary supremacy, you don't have to talk about devolution if an exam question asks you, right? But devolution as a chapter, that's quite important. That one will come later, right? So we're going to look at number 4, the manner and form argument. And then we're skipping devolution, right? So all of these pages you don't have to worry about. And this is a guarantee. This is not my opinion and I am giving you some suggestion. No, the university has clearly stated it's no longer part of the syllabus, right? Then we'll look at the Human Rights Act. Again, the Human Rights Act is also another chapter, but it does pose a bit of a challenge to parliamentary supremacy. We'll go through all of this quite relatively quickly. And then the big one that we will spend some time on is number 7, which is the membership of the European Union. This one we'll spend some time on. The reason is because even though the UK has left the European Union, and relatively, you might argue that this is no longer relevant or important, exam questions still come out on it, right? As recently as 2021, right? There was an exam question asking, in light of the UK's membership of the European Union, is Parliament still supreme? Right? Has it affected parliamentary supremacy? So, yeah, I mean, I'll be honest, I also think it is a bit strange because Brexit was done and finished, all completed in 2019. So by right, we shouldn't have to concern ourselves with the European Union so much, but exam questions are still coming out, and so we will focus on this, okay? Now, another note you might want to take when you are preparing for the exam, right? When you're preparing for the exam, the challenges number 1 to number 6, you can just know about it. You don't have to emphasize so much. I have not seen an exam question on those challenges specifically ever, right? The exam focus will always be on the first part of what we learned. That means, is Parliament still supreme in light of the judges, the ouster clauses, all of those things? Those things you need to be comfortable with, and the European Union. And the European Union. So this is why, this explains to you why I am going through the earlier parts relatively quickly. You should know about them. but you don't have to spend too much time on them. Okay? Okay, so let's go back to challenge number 4. What page is that on? Can you tell me? In your book, what page is that on? Because in my notes, it's page 10. Obviously, it's wrong, right? So what page is that on? Do you have page numbers in your book? What is that? 87. Okay, very good. Just for everyone to know, 87. Thank you. Okay, let's talk about the manner and form argument here. What is this manner and form? What does manner and form mean? Just normal English. Manner and form. Manner means the way you do something, right? That's what manner means, right? The way you do something. Form means the way you do, how it looks like. That's what form means. Manner is like the way you do something. What is the usual processes, procedures, and so on and so forth. And form means how does something look. So the argument here, ladies and gentlemen, is Parliament is bound by the way in which it does things. Parliament is bound by how Parliament has to make law. Parliament is bound by the processes and procedures to make law. And the law must look a certain way. So if you argue that Parliament is supreme, a truly supreme Parliament will not need to follow the processes and procedures. If Parliament tomorrow were to decide, okay, I don't want to follow the process of making law, right? So again, there is a chapter that you will learn the lawmaking process in the future, right? There's a chapter where you will learn the lawmaking process. You will learn that in the House of Commons, there is the first reading, second reading, committee stage, report stage, third reading. And then at the second reading, there is a vote. So on and so forth, right? At every stage, there is a process, there is a procedure that must be followed. And then once you finish all of that in the House of Commons, that act is sent to the House of Lords. And in the House of Lords, same process again. First reading, second reading, committee stage, report stage, third reading. And then there's an unofficial stage called the ping pong stage, right? Funnily enough, right? It's called the ping pong stage. Why? Because sometimes if the Commons and the Lords cannot agree, it is sent back and forth. Okay, I changed this. Okay or not? No, I want some more change. Send back. Okay, I changed this. Enough or not? They go back and forth, right? And once that is done, then the act, the bill, before it becomes an act, it is called a bill. The bill is then sent to the king for royal assent. Tomorrow, can the House of Commons decide this is just too much trouble? I don't want first reading, second reading. I just want, this is the bill. This is how we want it. Let's just send it straight to the House of Lords. Can that happen? Arguably, cannot. Right? A bill that if you want to go through an act of, you want to go through the process in Parliament, all those stages need to be complied with. And then it must go to the House of Lords, and then it must go to the king. If it doesn't comply with any one of those stages, that bill can be questioned as to its validity. So this is the issue. This is the issue. The issue here is a truly supreme Parliament will not need to be bound by processes and procedures. A truly supreme Parliament will not need to be forced to go through, follow those procedures, right? If really Parliament was supreme, Parliament can literally do whatever it wants. Okay, an example that is often quoted, right, of this is this particular case here. AG for New South Wales against Traytowen. AG for New South Wales against Traytowen. So firstly, we're not talking about the UK Parliament. We're talking about the Parliament of New South Wales. New South Wales is a state in Australia. It's a state in Australia. So the facts of this case was the Parliament in New South Wales, right? The Parliament in New South Wales was supposed to follow a particular procedure, right? They were supposed to follow a particular procedure before they did something. They did not do that procedure. The procedure was to have a referendum first. They refused to follow that procedure, and they went and did the act anyway. And the courts held that that act was illegal. So this case, AG for New South Wales against Traytowen, is often used as an example to show, look, parliaments are bound by the procedures. And the argument here is, if parliaments are bound by procedures, ladies and gentlemen, then parliaments are not supreme. But very quick counter argument. Number one, this case is not about the UK Parliament. This case is about the Parliament in New South Wales. The Parliament in New South Wales is not a supreme parliament. It never was a supreme parliament. The Parliament in New South Wales is not even the Australian Parliament. It's a parliament of a state in Australia, right? So you cannot compare the Parliament of New South Wales with the UK's Parliament. However, then the argument is, okay, fine, let's forget about the New South Wales Parliament. Let's talk about the UK Parliament. The UK Parliament also must follow the procedure, right? The UK Parliament also must follow the procedure. All right? But the counter argument here is that procedure is set by Parliament itself. Parliament is the one that says you have to follow this procedure. Why? Because of quality control and trying to make sure the acts that come out are good quality acts. So Parliament is the one that sets the procedure. And so that's why Parliament follows the procedure. If Parliament wanted to change the procedure, can it? Yes, it can. Then the question is, has it done it before? Yes, it has. We spoke about this yesterday. Remember the Parliament Act? The Parliament Acts of 1911 and again in 1949 changes the procedure, isn't it? What was the change in 1911? The Parliament Act says that the House of Lords no longer has the right to reject legislation, right? The Parliament no longer has the right to reject legislation. That in itself is a major change into the process and procedure. Not only that, the House of Commons now has the power to skip the House of Lords. The House of Commons has the power to skip the House of Lords entirely. That means they don't even submit the bill to the House of Lords for approval. They send it straight to the King. So, ladies and gentlemen, if you are here arguing, oh, Parliament is bound by the processes, Parliament is bound by the procedure, that's not a correct argument. Because if Parliament wanted to, Parliament will be able to change the procedure, and they have before. Not once, but twice they have. 1911, and then again in 1949. Now, if you're wondering what is the change between 1911 and 49, in 1911, the House of Lords can delay the legislation for up to 2 years. That was further reduced in 1949, where the House of Lords can only delay legislation for 1 year. Yesterday after class, someone came and asked me this question, which I thought was a very, interesting question. It shows that you're thinking a little bit. The question that was asked is, how was the Parliament Act 1911, how was that act passed? Because for that act to be passed, the House of Lords has to approve it. After that only, because as a result of the 1911 Act, yes, the House of Lords has reduced its power and all of that. But to pass the 1911 Act, the House of Lords could have rejected it. To pass the 1911 Act, the House of Lords could have vetoed it. What is the story there? Well, it's quite an interesting story. This is historical. Nobody's going to ask you this in the exam. In 1910, see, the reason why the entire Parliament Act was passed or was introduced is because in 1910 there was an election, and in the election, in a very unexpected election result, the Liberals won the election. So we have a prime minister, his name was Lloyd George, and for many, many years before that, the Conservative Party was the party in power. And everyone in power, everyone in power, from the civil servants and all, they were all very conservative ideology minded. This is a long time ago, 1910, isn't it? But then the Liberal Party won the election. The Liberal Party decided to, they were introducing their budget. The House of Lords blocked the budget. Now, this is in breach of a convention. You may have learned this story in conventions. This is a breach of convention. Because the convention was the Lords should always allow any kind of money bills. Why? The elected people should control money. The unelected people shouldn't interfere. So there was an understanding. But because now the government was the Liberal Party and the House of Lords was full of Conservative Party supporters, the House of Lords became a bit naughty. They decided to play political games and they blocked the budget. This is a clear breach of convention. But a breach of convention, as you know, you can't enforce it in court, isn't it? So this is why the government got very upset and they decided to introduce the Parliament Act, which reduces the power of the House of Lords. Since that day, since 1911, the House of Lords have had their powers reduced tremendously and they've never recovered. But a good question to ask is what was asked yesterday. Why did the House of Lords in 1910, why did they allow it? They could have fought. They could have fought back. The answer is this. The Prime Minister at that time, he played some gangster politics. That's what I like to call it. He told the House of Lords, if you don't pass this bill, I will immediately appoint as many members as necessary to the House of Lords to make this bill pass. See, a little bit of history you should know. The House of Lords is not an elected house, right? The House of Lords is an appointed house. And there is no maximum number of membership to the House of Lords. If today there are 800 members to the House of Lords and all 800 are against me, what will I do? Tomorrow, I will appoint 900 members to the House of Lords. I will just randomly grab people from the streets and I will say, I will make you Lord so-and-so tomorrow. You just need to vote for me. The House of Lords saw that. They saw that it was a real threat and they didn't want... See, if that happened, let me tell you, if that happened, the House of Lords would have become a real joke. Nobody will take it seriously anymore, and its entire reputation and the history will be destroyed. So what the Prime Minister was doing is, effectively, he was threatening to destroy the House of Lords. And then the Lords backed down. The Lords said, okay, fine. We made a mistake. Fine. So they themselves approved the Parliament Act of 1911 that reduces their power, right? So there's something to remember. But in the context of this parliamentary supremacy, does the manner and form of how to make law, does the manner and form of how to do parliamentary processes, does it mean that parliament is no longer supreme? The answer is no. Because yes, there are processes, yes, there are procedures that must be followed, but these processes and procedures are followed because Parliament wants to follow it. In fact, those processes and procedures are made by Parliament themselves. And if Parliament wanted to change it, Parliament can, right? So is Parliament still supreme? Yes, it is. In light of this challenge, Parliament is definitely still supreme, right? So I told you, really don't worry about devolution. You will learn about devolution later in a separate chapter. Let's get to the Human Rights Act. Okay. The Human Rights Act is a very, absolutely important act of Parliament. How important it is exemplified by the fact that you have a whole chapter dedicated to it in your syllabus. The full chapter, and from an exam point of view, right? Every year there is a question on the Human Rights Act. Okay? Now, what we are learning here is just the Human Rights Act in relation to parliamentary supremacy. This is not everything about the Human Rights Act. You'll be learning about that later. Okay, why is the Human Rights Act seen as a challenge to the doctrine of parliamentary supremacy? We are going to be focusing on two sections of the Human Rights Act, Section 3 and Section 4. But before that, a very quick introduction to the Human Rights Act. You may not have been introduced to the HRA before this, I realize, right? Okay, so what is the Human Rights Act? Firstly, the Human Rights Act is a UK Act of Parliament, correct? It is not any kind of external law. It is a UK Act of Parliament. But what does the Act of Parliament do? See, there is this thing called the European Convention on Human Rights, the ECHR, European Convention on Human Rights. The UK government is a signatory to the European Convention on Human Rights, right? The UK government has signed the European Convention on Human Rights. It is essentially a set of rules that say that all the governments need to uphold some basic human rights. Okay? Now, the thing with that is, although the UK government signed the European Convention on Human Rights, at home, the UK government doesn't always follow it. The UK government doesn't always follow it. Many times, the UK government will pass laws that take away the rights of the citizen in conflict with the ECHR. And then what happens? The citizen, he will go to his local courts and he will say, the government is doing this, please help. But the courts don't have a choice. The courts must follow the UK Act of Parliament. The citizen will say, but this goes against the ECHR. The courts will say, the ECHR is international law. I am a UK judge. My job is to follow UK law. The UK law says this, I have to follow. Then the citizen will lose in his local case, spend a lot of money knowing he is going to lose, High Court, Court of Appeal, House of Lords, and then he will appeal to the European Court of Human Rights. Then in the European Court of Human Rights, he will win. Now, the point is that takes a lot of money, that takes a lot of time, that takes a lot of, I got distracted. That takes a lot of time, money, and expertise, unnecessary. So even though the UK is a signatory of the European Convention on Human Rights, their citizens are not necessarily benefiting from it. Okay, so then, remember the young up-and-coming Prime Minister I told you back in 1997, Tony Blair. This was part of Prime Minister Tony Blair's reform proposal. Blair said, you vote for me, I will introduce the Human Rights Act. What does the Human Rights Act do? The Human Rights Act, so start listening from here. The Human Rights Act will force the judges to follow the ECHR, even sometimes if it conflicts with the UK Act of Parliament. This is why we are studying it here. So if a UK Act of Parliament says ABC, but the European Union, the European Convention on Human Rights says something else, the judge today, because of the Human Rights Act, the judge doesn't exactly need to follow the UK Act of Parliament. He doesn't have to. He can interpret the act to make it in line with the European Convention on Human Rights. This is the power that the HRA has given to UK judges. And it is because of this extra power given to the judiciary. This is also why the argument is that the Human Rights Act is a challenge to parliamentary supremacy. Because again, like I told you yesterday, right? What is the traditional role of the judge? The traditional role of the judge is to apply the law. That's it. Whatever Parliament says, the judge applies. The judge doesn't question, the judge doesn't say that, oh, this is not right. Well, he can give his opinion, but at the end of the day, he must still apply the law. But the Human Rights Act today, as we are going to see, the Human Rights Act gives the judges today the power to even change the meaning of the statute, change the meaning of the Act of Parliament. And that, ladies and gentlemen, is why people say that maybe the HRA is a challenge to the doctrine of parliamentary supremacy. Let's see, right? So the two sections that we are going to look at is Section 3 and Section 4. Let's look at Section 3 first. So remember, this is a UK Act of Parliament telling the judges to do this. Look at Section 3. Section 3 says, as far as it is possible to do so, all primary legislation and subordinate legislation must be read and given effect in a way which is compatible with the Convention rights. The Act is telling the judge, when you interpret the UK laws now, when you interpret your UK laws, you must read it in a way that is compatible with the Convention rights. You must read it in a way that is compatible with the Convention rights. What does that mean? That means, ladies and gentlemen, very simply put, if the statute says ABC, but the ECHR says XYZ, the judge now is supposed to interpret ABC to mean XYZ, even though it is clearly ABC. Does this undermine Parliament? Right? Okay, we shouldn't just stick to ABC and XYZ, isn't it? We should look at some real cases. So let's look at some cases. Okay, Ballinger against, Ballinger is Section 4. I tell you what, right? Let me give you a case for Section 3. You just take it down. R against A. A very, very easy case to remember, right? R against A, specifically section. It is about Section 41 of the Youth, Justice and Criminal Evidence Act. Section 41 of the Youth, Justice and Criminal Evidence Act. Okay, just listen to the story, right? You will learn this case again when you study the HRA. But this is an example of the power today that the judiciary has that some people argue undermines Parliament. Why? The Youth, Justice and Criminal Evidence Act, Section 41 says, in a rape trial, in a criminal case, a rape trial, the victim's past sexual history is not relevant to the trial. Okay, I repeat that. In a rape trial, the victim's past sexual history is not relevant to the trial. Let me tell you why Section 41 was brought about. See, what used to happen in the UK is when someone is raped, a woman is raped, a lot of the time, the women affected, they don't even want to go to the police. They don't see any value in going and making the report. Because for them, number one, the police is going to laugh at them. It's embarrassing. And then in court, the accused person's lawyer is going to destroy them. What do you mean by destroy them? You see, for the offense of rape, some of you are doing criminal law, isn't it? I think the elements of rape, if I'm not mistaken, you correct me if I'm wrong, there are two things to prove. Two things to prove. Number one, sex. So penetration, the actual act of sexual intercourse, penetration. And number two is without consent. It must be sex. Or actually, I shouldn't say sex. It must be penetration without consent. These are the two things. Usually the sex part, the penetration, is difficult to disprove. There will be semen, there will be bruising, there might be a lot of physical evidence that the sex happened. So I'm the defense lawyer. I can't fight that. So what do I have to fight on? The consent. How do I fight on that? Then now my job is to paint the victim out to be a terrible person. I will say, you had condoms in your handbag. That means you are out looking for sex. I mean, obviously it's not, isn't it? You can keep condoms in your handbag if you want, right? That's your business, isn't it? But what will I do? I will say condoms were found in your handbag. That means you were that day, you were out looking for sex. You found my client as a victim. And so you had sex with him, and now you are saying rape. Or this is what I will do. I will call the bartender, and he will come and give evidence. This lady comes to this bar all the time. Every time she comes to this bar, she will go back home with a different guy. See, what am I trying to do here? I'm trying to paint you out as a, excuse my language, as a slut. I'm trying to paint you out as someone that probably said yes to him. Now she's turning around the story, isn't it? That's what I will do. I'm the defense lawyer. That's my job. Because of things like this, women felt that it was ridiculous. Why should I put myself through this? There was a saying, you get raped all over again in court. So because of this, Section 41 was introduced. So Section 41 says your past sexual history is not relevant in a trial. Your past sexual the victim's past sexual history is not relevant. So you may have slept with 100 men. That's fine. It is not relevant. You cannot bring in the evidence. Oh, you see, she has slept with 100 men before, so she is that kind of woman. That means she probably was asking to be raped. Stupid, lah. So the law doesn't allow that anymore. Are we good? Okay. Is this a good thing? Yes. 100% it's a good thing, right? So make it very clear. Section 41 says the victim's past sexual history cannot be brought into court. Okay. Settle. How is this relevant to HRA? Let me tell you this. In this particular case, R against A, the accused person is saying Section 41 is unfair to him. The accused person. Section 41 is unfair to him. He is saying that part of my defense is that I have to show that we have had a prior sexual relationship. But now I cannot. I cannot bring in the evidence to show that me and the victim, we have been having sex regularly. She is not my girlfriend, but it's someone that we usually have sex with, and then we go back home. Right? Not right? I don't hold your hand. I don't carry you and take you to show you to my mother. All don't have. Our relationship is we come, we have sex, we go back home. But now I cannot show that because that evidence can go to show that, look, It's not just, this is not just a random rape. There was a prior sexual history between us. But because of Section 41, I, the accused person, I cannot bring in your past sexual history. The argument here is, that's not fair. The argument here is, that's not fair to me. I cannot get a fair trial. Okay. What does the Act of Parliament say? The Act of Parliament is very clear. The victim's past sexual history cannot be brought. Full stop. What did the courts do in R against A? The courts looked at the statute, Section 41, and they said, yeah, this might be infringing on the accused person's right to a fair trial, Article 6 of the ECHR. Because if I cannot bring in any evidence that I think is relevant, then it's not fair to me. But this is what the judge said. He said, I will listen to the evidence first. The jury will be sent out. The jury will be sent out. I will listen to the evidence first, and then I will decide whether that evidence can be brought in. And then we will bring the jury back, and then we will hear the evidence. Okay? Now, some of you are sitting there and thinking, oh, that's a smart judge, right? Fair. But you see, the point is, the statute says what? The statute says the victim's past sexual history cannot be brought into court, full stop. But what is the judge doing here? The judge has changed the meaning of the statute. The judge has changed the meaning of the statute to mean the victim's past sexual history cannot be brought into court unless the court says can. But that's not what is written in the statute. Can the judge do that? The answer is can. Why? Section 3. Section 3. Section 3 of the HRA says that it is now the duty of the judge, when he is reading a statute, he must interpret the statute in a manner that is compatible with the ECHR, which means later when you study the HRA chapter, we will see this in far greater detail. Right? We will look at the words of a lot of cases and all, which means the judges have said, Lord Nichols, in the case of Guyden against Mendoza, he has said, the judge is able to change the meaning of the words. The judge is able to add words in. The judge is able to take out words. Section 3 allows the judge to do that. Doesn't that seem like the judge is rewriting the statute? I'll give you another case, right? Guyden against Mendoza. The issue here is the word spouse. Okay, let me tell you this story. Guyden against Mendoza. The issue here is the word spouse. So, in the UK, they have these things called this special leases where it is rent controlled. I don't know if you guys have this in Hong Kong. Certain parts of London, certain parts of the big city, it will be a rent controlled area, which means the landlord cannot simply raise rent. Parliament will determine what is the maximum rent for that area. And then every 5 years or every 10 years, they will move it up a little bit. But the landlord doesn't get to decide. Parliament decides. Why? Why? To ensure that people have an affordable place to live, right? They want to make sure that. So this kind of rent control, if you have a rent control lease, it's like gold, right? The law says, if I have a 10-year rent control lease, when I die, I can pass the lease on to my spouse. Because it's so precious, right? Getting a rent control lease is a big deal. I can pass the lease on to my spouse when I die. Okay. Guyden against Mendoza, the issue was an homosexual couple, 2 men. Two men who are in a long-term, stable, loving relationship. Now, again, you must understand, Gaiden is, I think Gaiden is 2001, 2002, around there. So this is some time ago. The law in the UK had not changed then. Today, homosexual couples or straight couples can get married. So that's not an issue, but back then don't have. So the issue here was the word spouse, right? When Parliament used the word, when you die, you can pass the lease on to your spouse. What is the meaning of spouse? The normal, ordinary dictionary meaning of the word spouse is what? Husband or wife, isn't it? Not just your boyfriend or girlfriend that you call husband or wife. You must actually be married, properly married in the eyes of the law, signed all the papers and everything. Then you are spouse. So in a homosexual relationship, that person, no matter how much you love him or her, no matter how much you are committed to that relationship, you are not a spouse. That's it. You are not a spouse, full stop. Cannot be spouse, isn't it? And Parliament obviously meant spouse in the traditional sense. It is very clear that Parliament meant spouse in the traditional sense. What did the court do? The court used their powers under Section 3, and they said spouse also means long-term homosexual couples. They expanded the meaning of spouse. Okay. Did Parliament mean that? The answer is a clear no. But the courts changed the meaning of what Parliament meant. And who allowed them to do that? Arguably, the Human Rights Act. Section 3 of the Human Rights Act allows them to do that. So the meaning of what Parliament meant, the meaning of Parliament's words are being changed by the judges. And the mechanism that allows this is the Human Rights Act. So, ladies and gentlemen, is the Human Rights Act a challenge to parliamentary supremacy? Right? And then, very quickly, let's look at Section 4. Section 4, right? Specifically 4 sub 2, right? That's the focus, 4 sub 2. If the court is satisfied that a provision is incompatible with the convention rights, if the court is satisfied that the provision is incompatible with the convention rights, the court can declare that provision incompatible. This is what we call a declaration of incompatibility. Ladies and gentlemen, judges have never had this power before. Remember, I told you the traditional role of the judge is what? Apply the law, full stop. But today, the Human Rights Act says that. So you see, Section 3 and Section 4 work together, hand in hand. The judge is supposed to now, he'll take the law, he's supposed to see whether he can, no, the first thing he's supposed to see is the law compatible with the ECHR? If yes, very good. If no, his first thing he's supposed to do is, can he interpret the law to make it compatible? Just like in R against A, just like in Gaiden against Mendoza, can he interpret the law to make it compatible? If he can, very good. But if he cannot, that means the word is so obviously, it cannot come under the definition of interpretation anymore, right? That means it'll cross the line. So then he uses Section 4. He declares that the Act of Parliament is incompatible. Ladies and gentlemen, we've never heard of this kind of powers being given to the judiciary. The court can say that this law is incompatible with the convention rights. It's a big deal. Right? But you must remember, it is not that the law can be invalidated. No one can question the validity of an act of parliament. This is just the parliament just putting a stamp on the law saying this law is not compatible with the ECHR. So now, ladies and gentlemen, reading section 3 and section 4 together, do you think today the courts have been given a lot more power, which results in Parliament no longer being supreme? The quick counter argument is this. Yes, go back to section 3. Yes, the courts today can interpret legislation sometimes in a totally different way than what Parliament intended. They can. But if you read section 3 sub 2b and you read section 3 sub 2c, 3 sub 2b and 3 sub 2c say, no matter what the judge does, the validity, continuing operation, or enforcement of the legislation is not affected. That means that law, remember section 41 of the YJCEA? The judges went and changed the meaning. They interpreted it differently, right? What happens to section 41? Nothing. Nothing happens to section 41. Section 41 is still valid law. The courts cannot declare that the law is invalid. The courts cannot declare that the law is wrong. The courts don't have that power. Even if you look at section 4, a declaration of incompatibility. What is the effect of a declaration of incompatibility? If you read section 4 sub 6, 4 sub 6 says a declaration of incompatibility has no binding effect on any of the parties in court. Right? Do you have 4 sub 6 here? 4, 2, 3, 4. Right? You can write down there 4 sub 6. Right? Sub 6 clearly says that the declaration of incompatibility has no binding effect on the parties in court. Ladies and gentlemen, then what are we talking about then? Right? So the HRA, yes, the HRA has given a lot more powers to the judiciary, but let's go back to the core question of parliamentary supremacy. Can Parliament still make or unmake any law? Answer is yes. If tomorrow Parliament wanted to make a law that goes against the ECHR, can they do that? The answer is yes, they can. Can anyone question the validity of the Act of Parliament? Not the incompatibility, the validity of the Act of Parliament. The answer is no. The court still cannot question an Act of Parliament. Can Parliament bind its successors or be bound by its predecessors? Arguably also no. So, ladies and gentlemen, although the HRA is a powerful act, the HRA has empowered the judiciary a lot. I think there's no doubt there. The HRA has strengthened the judiciary tremendously. But does that mean Parliament is no longer supreme? The answer is no. Because ultimately, guys, the HRA itself is just another act of Parliament, isn't it? If Parliament wanted to repeal the HRA, can they do so? Yes, they can. In fact, guys, when we study the HRA chapter, I'm sure you will learn, there is actually currently a bill in Parliament to repeal the HRA. But that bill is kind of dead in the water, right? What do I mean by that? The minister, there was one minister, his name was Dominic Raab. He was very keen on repealing the Human Rights Act. The Conservative Party doesn't like the Human Rights Act. Because remember, Tony Blair, who introduced the Human Rights Act, was from the Labour Party. The Conservative Party, they really, really don't like the Human Rights Act because for them, they see it as, oh, these Europeans are controlling us. The European Convention of Human Rights. How can we let outsiders control us? By the way, in the event you are thinking it, the ECHR is not part of the European Union. Separate things. The European Convention on Human Rights is not part of the European Union. So if you are asking, we left the European Union already, why are we still complying with the ECHR? These are separate things, right? The European Convention on Human Rights is not part of the European Union. Okay, right. So, the conclusion, is Parliament no longer supreme as a result of the Human Rights Act? The answer is no, right? The answer is no. Parliament is still supreme, but it is a significant challenge, right? I mean, it's a very real challenge, but if you argue it out, the answer is no. Parliament is still supreme. Right? Okay, so let's get into the last one, which is membership of the European Union. Okay. Today's class is a 4-hour class. So in a 4-hour class, we will take 2 breaks, right? Every 1.5 hours. So 11 o'clock and then 12:30. Okay, or thereabouts, roughly, right? Okay, so membership of the European Union. Firstly, let's talk a little bit about the history of the European Union so that you understand its context. I don't know, maybe some of you in your own jobs, your businesses, you have to deal with the European Union. You've got businesses there, or maybe you deal with European Union laws or whatever. The European Union is what we call a supranational organization. A supranational organization means it is an organization that is above countries. Countries join the European Union and then they agree to become a part of this bigger organization. Okay? How the European Union started is, like most things, it started about money. The Europe realized that after World War II, Europe realized that it is just stupid to fight, right? Because World War II was about European countries fighting against European countries, isn't it? And the devastation that war brought about was just so silly. So some of them decided, why don't we go the other way and why don't we cooperate on things? So slowly what started was European cooperation on specific matters. So what do I mean by specific matters? That means they started with the European Atomic Energy Council. That means all of the European countries will work together on atomic energy. Then there was the European Steel Commission. They will work together purely on steel. So like that, there were a few specific industry-specific cooperation throughout Europe. And it was working well. It was doing well. Then they thought, okay, if it's working well, why don't we get together for everything? Economic related. So then at first it started the European Economic Community, right? The European Economic Community. So they said, okay, let's start working together on economic matters. It makes a lot of sense, isn't it? If I am a British guy and I want to sell my products, prior to this, I can only sell to 70 million English people or British people. But now I get to sell to 450 million European people. Why? Because of the cooperation. If I want to sell in Germany, there's a lot less tariffs and barriers. If I want to sell in Spain, they've reduced all the barriers. It's as if I am selling in my own country. I go to another country and I sell. This is a wonderful thing. So everybody's happy. They started the European Economic Community. And then when the cooperation on economic matters was doing so well, what is the next step? Let's not stick to economic matters only. Let's move on for cooperation on other things as well. So what are other things? The environment, defense, everything. So then what they did is they dropped the word economic and they called it the European Community. And then as the years progress, so on and on and on, they realized that community is not such an effective word, because the cooperation is becoming so much more closer. If you look at the European Union today, it is as if they are one big super country now. There is a European Union president. Did you know that? Nobody knows him now, right? Because he's not that famous, but there is a president, they have a European Union parliament, they have a European government, they have a European civil service. It's like one big country. So they decided community is a wrong word. They want to call it the European Union. Union connotes like, like you are one. Community connotes like you are many and you're just hanging out together, right? That's a community. But a union is, we are all one. So ladies and gentlemen, that is a very, very brief history of the European Union, right? An extremely brief history. Now, why is this important? So we need to understand how the UK joined the European Union. So the UK was one of the people in the beginning that were part of the discussion to create the European community, right? And then in 1972, or just before that, the UK signed the agreement to join the European Union. But the way the UK's constitution works, just because the government signs a treaty out there doesn't mean that it is recognized at home. Something must be passed at home. Then only it is recognized. So the government came back, and then in Parliament, they passed the European Communities Act, 1972. Ladies and gentlemen, our entire discussion is going to be on the ECA 1972. So again, don't get this wrong. The ECA is an act of the UK Parliament. The UK Parliament passed the European Communities Act 1972, which essentially is like Parliament's permission to the government to join the European Union. Are we okay, everybody? Okay. Now, the issue here is this. By the UK joining the European Union, does it mean that Parliament is no longer supreme? By the UK joining the European Union, has it resulted in the UK Parliament losing its supremacy? So in order to understand this, we are going to look at a few sections in the ECA, and then we're going to look at a few cases. Now, before we even start, I just want to, I know all of you know this, I know you know this, but just for me, I have to make it very clear. The UK is no longer part of the European Union today. Okay? The ECA 1972 has been repealed. The ECA 1972 is no longer law, right? If you think you will forget that, just write it down somewhere. I'm very scared someone will write in the exam as if the ECA is still valid law. It is not. It is no longer law, right? It has been repealed by the European Union Withdrawal Act 2018 as amended by the European Union Withdrawal Act 2020. Okay. So when I say that like that, I totally understand if some of you are like, so already repealed already, why are we still learning it? What is the point? Well, the point is there are still exam questions that ask you about this. And so the issue here is, as of today, is Parliament still supreme in light of the European Union? The answer is, of course, yes. Why? Because the UK is no longer a member of the European Union. So 100% yes, Parliament is still supreme. Then what is the issue? The issue is, during the time that they were in the European Union, did Parliament lose its supremacy or not? During the time when they were in the European Union, did Parliament lose its supremacy or not? So this is purely an academic question. It is not a practical question at all. Because practically today, of course, Parliament is supreme. Because it's no longer part of the European Union. So this is purely an academic debate that we are going to be having. Are we good? Okay, let's continue. Now, the main parts of the ECA that we are going to look at is section 2 sub 1 and then section 2 sub 4. Okay, let's look at 2 sub 1 first. Now, this is not the actual wording of 2 sub 1, right? This is a paraphrasing, summarized version. Two sub 1 says this. All EU laws, all European Union laws. And after this, we are going to learn what it means when I say European Union laws, right? All European Union laws that have been passed by the European Parliament or the European Commission, because in the EU, their lawmaking process is different. There are 3 bodies that can make law: the Commission, Parliament, and the Council. So any European Union law that is intended to be directly applicable. Now, I want you to note that this term directly applicable is not a normal English word. It is a technical term. The term directly applicable means when it is passed by the European Union, when the law is passed by the European Union, it is intended to have effect in the member states immediately with no further changes. I repeat, the term directly applicable means when the law is passed by the European Union, it is intended to have effect in all the member countries without further interference by the member countries. Without further interference by the member countries. That is what direct applicability means. Okay, so let's look at that again. All European Union laws, see, the wording still uses community law because in 1972, it was still called community, okay? So everywhere you see community, it means union, okay? So all European Union laws which are intended to be directly applicable will be given the force of law. This applies to community law made both before and after the coming into force of this act. This is not the actual wording of the act, but this is what it means. Can you tell me what it means? What is the effect of this 2 sub 1? Let's look at it clearly. Doesn't it seem to you to say that now any law that is passed by the European Union, and that law, if the European Union says this law has direct effect, any law that is passed by European Union will now become law in the UK. Full stop. Would you agree with my interpretation? Well, you should, because it's correct. Right? Effectively, 2 sub 1 of the ECA is telling us this. Any European Union law that has direct effect will automatically become law in the UK, will be given the force of law. That means the citizen now, ladies and gentlemen, he can go to his local court in the UK and he can use a European Union law, even if that law is conflicting with a local law. Even if that law is conflicting with a local law. Look at 2 sub 4. 2 sub 4 says, Acts of Parliament passed after 1972. Acts of Parliament means UK laws. UK laws passed after 1972 must be construed. Construed means what? What is the meaning of the word construe? Construe means must be interpreted. UK laws passed after 1972 must be interpreted and have effect subject to the provisions of the ECA 1972. Ladies and gentlemen, this 1972 Act is trying to tell us all future acts of Parliament must be interpreted in a way that is compatible with the ECA 1972. And what does the ECA 1972 effectively say? It says, you must give priority to community law. Ladies and gentlemen, this is why so many people in the UK were upset about the European Union. I mean, obviously, the politicians also really played this up, right? The politicians played it up. They scared the people of the UK. And that's why the people of the UK came out in large numbers and they went to vote to leave the European Union. Ladies and gentlemen, if you follow this, studies have shown that the UK today is suffering because it left the European Union. I'm not saying suffering like the people in the streets are dying and crying, no, that's not what I mean. But the economy has definitely been impacted negatively because they have left the European Union. And a lot of people are regretting voting to leave the European Union. This was purely politics, This is the danger of politics, right? This is the danger of politics. Politicians go to the people and they tell them scary stories. And this happens in politics everywhere, right? Politics is all about having one person to scare you. And I don't know Hong Kong politics, so maybe it's not here. But effectively, politicians will say, you look at him, you better vote for me. If not, means he is going to come and he will take you. He will eat you. He will take your money. He will take your jobs. He will take your prosperity. You vote for me, I can stop him. If you don't vote for me, he will come over and he will take over and take everything and go. This is what we call boogeyman politics. That's exactly what happened in the UK. Right, the Conservative Party or some extreme right wing, because not everybody in the Conservative Party agreed to leaving the Brexit. The Conservative Party itself was split in half. The Prime Minister at that time, David Cameron, he was actively fighting to not leave. But it is people like Boris Johnson, Michael Gove, Theresa May, these are all your Brexiteers. And we have seen how good a Prime Minister Boris Johnson was. But in case you don't know, he was terrible, right? So the point I'm making is, this is the kind of thing that scared a lot of citizens in the UK. Because if you read this, it seems like now, who makes law for the UK? Yeah, Parliament can make law. Of course, Parliament can still make law, but we have all these foreigners, these European people. They also can make law, and if they make law, their law can be directly applicable in our country. And what if our law and their law is in conflict? Later we will see the cases. Their law must win. The way I have presented it is quite scary, isn't it? This is what politicians do. But to be fair, it is also true. It is. I'm not lying to you. I'm presenting it in a scary way, yes, but it's not wrong, because that is effectively what the European Communities Act does. Section 2 sub 1 and 2 sub 4. These are the two important sections. Now, just looking at the sections won't be enough, right? So we need to understand how have the courts interpreted 2 sub 1 and 2 sub 4, right? How have the courts interpreted 2 sub 1 and 2 sub 4? The courts have taken three approaches. The first approach has been declared to be absolutely wrong. So you can totally ignore the first approach. What is the first approach? The first approach is they decided to ignore the European Union Act, the ECA, totally. They said, no, we are judges, we will apply the later act. So if the European Union law comes first, and then later a UK Parliament Act comes, we will apply the UK Parliament Act, because whichever act that is later in time will prevail, right? That approach has been declared to be absolutely wrong, right? So this was an initial approach, which today doesn't apply anymore, right? So what the courts use today is the construction approach, let's say, for example, or the disapplication approach. Now, let's look at a few cases here. Again, when you look at these cases, what is your focus? you are looking at these cases to see, is it true that an act of parliament today can be ignored by the courts? Why? Because they are following European Union laws. Because if that is the case, then arguably parliament is no longer supreme, isn't it? Okay, so let's look at this case, McCarthy's against Smith. McCarthy's and Smith is an interesting case. It was a gender discrimination case. Gender discrimination in the sense that Mrs. Smith, McCarthy is the company. Mrs. Smith joined the company and she replaced a man in the same job, same responsibility. But the man was in the job earlier, then the man left and she took over the job, but she was paid less money. Right? She was paid less money. So she is bringing an action against this, saying that this is in violation of the Equal Pay Act, the gender discrimination and all of that. So this is the problem. This is the problem. The Equal Pay Act, which is the UK law, right? The UK law says a man and a woman, if you are working at the same time, at the same job, you must be paid the same amount of money. Everybody clear? If you're working at the same time, at the same job, you must be paid the same amount of money. Okay, that's good. But the Equal Pay Act is silent. Doesn't say anything about what if the woman comes after the man. That means he takes over the same job. Does she have to be paid the same? It doesn't say that. Now, logic would dictate that, yes, of course you must pay the same, right? But the law was silent on it. So the company is jumping on that. The company is jumping on that and saying, look, the law doesn't say that we have to pay her the same because she didn't work with the man at the same time, at the same job. She came after, which is true, right? That's what the law says in the UK. However, there is also European Union legislation, Article 157. The European Union legislation says there must be equal pay for men and women regardless of when they work. Right? Regardless of when they work. So, ladies and gentlemen, what are we facing here? We are facing a problem. There is a UK law and there is a European Union law, and it is in conflict. Right? There is a UK Act of Parliament, and then there's a European Union Act of Parliament, and it seems like it is in conflict. Ladies and gentlemen, what should the judge do? Again, don't read first. Let's just talk about it. If Parliament was truly supreme, the argument is the judges will follow the UK Act of Parliament, isn't it? So this is the issue. Because obviously, as you probably have guessed, in this particular case, Lord Denning said, no, we are going to follow the European Union law. You see what he says, Here. In construing, this is a very famous quotation from his case. In construing our statute, we are entitled to look at the treaty as an aid in the construction. So he said, you can look at the treaty to help us interpret our laws. But he says, not only as an aid, but as an overriding force. That's strong words, He says, an overriding force. Lord Denning is telling us, and this is in the House of Lords, Lord Denning is telling us that the European Union law is an overriding force over our laws, right? Then he says, if on close investigation, it should appear that our legislation is deficient. That means if our laws got some deficiency, that means it's not the same as the European Union laws. For whatever reason, right? Or is inconsistent with community law by some oversight of our draftsmen. He's being very kind to the politicians. He's saying, or maybe the draftsman made a mistake. Huh? Actually, everybody knows that's rubbish. Huh? The politicians, they know exactly what they're doing, isn't it? But he said that by some oversight of our draftsmen. These are strong words again. Huh? He says, then it is our bounden duty to give priority to community law. He didn't say this is our suggestion. He didn't say it would be nice. He didn't say, I think you should. No, he used strong words. Lord Denning said, it is our bounden duty to give effect to community law. This is the effect of 2 sub 1 and 2 sub 4 of the ECA 1972. How, ladies and gentlemen? Is Parliament still supreme? Our courts are telling us. But look at the next paragraph. Thus far, I have assumed that Parliament, whenever it passes legislation, intends to fulfill its obligation under the treaty. Okay, fine. Lord Denning also tells us, if sometime in the future, if Parliament purposely passes a law, deliberately passes an act, which is in conflict with the treaty, and says so expressly. This obviously never happened, but Lord Denning is telling us, if one day Parliament says, this law is not complying with the ECA, not complying with the European Union, and we know it's not complying, and we want it to not comply. Then Lord Denning said, then we will follow Parliament. Then we will follow Parliament. But unless Parliament says that, we will assume that Parliament also wants to comply with the European Union laws. Parliament wants to comply with the European Union laws. So we will interpret everything they say, we will interpret it as if to comply with the European Union laws. Whatever Parliament says. Is Parliament still supreme like that? Okay, never mind. One more case. One more case. It will help you understand. So this is the construction approach. That construction approach was used in many other cases. Pickstone, Litster, right? Then there was the disapplication approach. This one, we see it best in the factor tame case. I tell you what, let's take a break now. Right? Let's take a break now. 10 minutes, we come back, we continue with the factor tame case. Okay? So I apologize for being late. Okay, let's continue. So we have looked at one case, the McCarthy's against Smith case. Doesn't look good for parliamentary supremacy. Let's look at another case. This is a big one, huh? Factor Tame. So let me tell you about Factor Tame. The facts are here. You can see that. So let me just do it like this. Crown against the Secretary of State for Transport ex parte Factor Tame. Do you know why a case is written like this? Well, just general knowledge, right? If you see a case and the case says John versus Smith, what can you tell from this case? John is the plaintiff. John is suing Smith. Smith is the defendant. This is a civil case. So it could be a contractual dispute. It could be a tortious claim. That is what the case is about, right? And then when you go on appeal, let's say John won the case and Smith is unhappy. Smith appeals to the Court of Appeal. How will the case be then? Smith versus John. Because now Smith is the appellant and John is the respondent. Okay? So again, this has got nothing to do with your public law, but I think these are important things. And again, I know I've been saying this many times. These are the kind of things you will learn in LSM. The basic stuff, which in my opinion is not great that the university doesn't require you to study. But that's my opinion. No problems, right? Don't worry about it. Right? So, okay. So why is there suddenly a case like this then? So if it's a criminal case, by now you know all criminal cases R versus John. When you see R versus John, R means Regina or Rex. Regina if there's a queen, Rex if there's a king. R against John means it's a criminal case. But then what happens when it's R against the Secretary of State for Transport ex parte Factor Tame? So let's try and understand this first. Ex parte means one party. Ex parte means one party. What is the opposite of ex parte? The opposite of ex parte is inter partes. Inter partes means between parties. Ex parte, one party. So when you see a case like this, ladies and gentlemen, what this is that this is judicial review. Because you must understand what judicial review is. Judicial review is you are unhappy with the decision of the government. You go to the court and you tell the court why you think the decision of the government is wrong. And the court will make a decision. The government sometimes doesn't even have to be a party to the case. They can be if they want, but they don't even have to if they're like, okay, well, let the court decide. Right? So judicial review is where you go to the court and you're asking the court to look into the decision of the government on behalf of you. So Crown against the Secretary of State for Transport. So this is not a criminal case, even though you see R versus Secretary of State for Transport, right? It is not a criminal case. This is a judicial review case, right? So understanding that will help you whenever you read a case, even without having to read the facts of the case. When you just see the name of the case, you will know certain details about the case already, and that's useful, right? Okay, so what happened in this case? What's the story here? So like I said, this is judicial review. In the European Union laws allow for free flow of trade and persons. What does that mean? That means, like I said, if you are an English person and you want to go to Spain to work, you can. If you are a German person and you want to start a business in England, you can. It will be made very easy. right? Usually when you go, you are a foreigner, you go to another country and you want to start a business, you want to work, there's a lot more processes, procedures, they make it very difficult. Under the European Union, no more, right? You should be able to go from one country to another as if it is your own country. You know, just imagine if you are born or you live in a Hong Kong example, you live in the New Territories, but you want to work on the island. You don't need to get a special permission, a special pass, work permit, all that, no need, right? But if you wanted to go and work in Malaysia, there's a whole bunch of processes and procedures that you need to follow. They are removing all of that, which is a good thing. Okay. So there were a lot of continental European fishing boats that used to come to the UK and fish. Why they come to the UK to fish? Number one, UK is an island, isn't it? Right, so there's a lot of waters, right? There's a lot of fishing that is available, and it's good fishing. So all these European companies will come to the UK to do their fishing. Now, usually these European companies, when they come to the UK to do their fishing, they are big companies. That means they've got huge boats, their technology is amazing. And what is happening here? The English fishermen, the small-time English fishermen, they are suffering because they cannot compete with these huge boats, with this amazing technology that this continental European guys are having. So they cannot compete. So what happens? They complain to their government, the UK government. Now, this becomes a political issue already, isn't it, right? It becomes a political issue. Why is it a political issue? This is exactly what happened the last time. Huh? Smart camera is not very smart. The last time I came and did class, they assured me you don't have to worry about the camera. The camera will follow you. Now, to be fair, I think it does. You see, obviously, right? Okay, anyway, forget about that, right? So let's come back to the story, right? Let's come back to the story. What was I saying? Oh yeah. So these European companies, they were coming to the UK and they were fishing, and the local fishermen, the English fishermen, just had no chance, right? So they complained to their government. It became a political issue, and then what happened? It became a political issue, and so because of that, the UK government passed the Merchant Shipping Act. The UK government passed the Merchant Shipping Act. Now, what does this Merchant Shipping Act say? The Merchant Shipping Act essentially says that if you want to fish in UK waters, UK territorial waters, your ship or your company must be owned, at least 75% owned by a UK company or UK individual. I say that again, huh? If you want to come and fish in UK waters, your boat or your company must be at least 75% owned by a UK citizen or a UK registered company. Right? Okay, interesting. This is what we call protectionism, isn't it? Right? But you see, this kind of protectionism and entry barriers is exactly what the European Union is trying to remove. They don't want any kind of barriers in between the country. They want people to be able to move from one country to another country smoothly. So the UK government has passed this. This is directly in conflict with European Union law. There's no doubt about it. So what Factor Tame has done, so who is Factor Tame? Factor Tame is a Spanish fishing company. Factor Tame is a Spanish fishing company, and they are now bringing an action against the Minister for Transport, right? The Secretary of State for Transport, because he is the one that initiated this legislation. They are bringing an action against him effectively to say that the decision of the minister to pass the Merchant Shipping Act is wrong because it goes against the European Union laws. Okay, who's the judge in this case? Right? The judge in this case, the judge is Lord Bridge, right? Lord Bridge in the House of Lords, right? At first, the Court of Appeal and the House of Lords were a little bit concerned. They didn't know what to do, right? So they said, the courts, we don't have the power to suspend an act of parliament. Right? Which is true, isn't it? Parliamentary supremacy. The court said we don't have the power to suspend an act of parliament. But then the appeal went up to the European Court of Justice. Again, now please note that this is a different court from earlier. That one was the European Court of Human Rights, right? This is the European Court of Justice. It's the ECJ, it's the EU's court. An appeal went up to the ECJ, and the ECJ said, no, the local courts must set aside that law. So the ECJ, the European Court of Justice, is telling the House of Lords, you cannot allow that law to continue. This is putting the House of Lords in some difficult situation, isn't it? Right? Can you imagine? It's a tough situation. Domestically, they have to uphold parliamentary supremacy. What does that mean, upholding parliamentary supremacy? You must give effect to the Act of Parliament. Parliament has passed the Merchant Shipping Act, so they're supposed to. But they, at the same time, they know they also have to uphold European Union laws. Why? Because the UK is a member of the European Union. You join a club means you must play by the rules, lah. If not, means you can't join the club anymore after that. So they are stuck in the middle. So when the ECJ told them, you have to do something, the House of Lords then, what they did was, they suspended the Act of Parliament. Ladies and gentlemen, this was a very earth-shattering type of judgment at that time, right? They suspended the Act of Parliament, the Merchant Shipping Act. The House of Lords, ladies and gentlemen, the House of Lords kept that act in abeyance. That's the word they use. They disapplied it, or they suspended it, whatever word you want to use. Now, this is the thing. The moment you see, oh, the House of Lords suspended the Act of Parliament, you are now immediately saying, this is proof that Parliament is no longer supreme. Full stop. End of story, isn't it? But Lord Bridge in the House of Lords went out of his way to clarify. And this is what he said. He said, the Merchant Shipping Act is still valid law. Why? Because no court can question the validity of an Act of Parliament. It is still absolutely valid law, just that we will not use it forever and ever. Can you see how Lord Bridge tried to do a very difficult job. He tried to keep both sides happy. So at the same time, he is reassuring us that Parliament is still supreme. Why? Because in the future, if Parliament wants to pass another Merchant Shipping Act, can they do that? He said can. Can Parliament still pass or make or unmake any law? He said can. Can anyone question the validity of an Act of Parliament? He said cannot. We also are not questioning that the Merchant Shipping Act is valid law. We are not questioning it. It's just that we are declaring that that law can never be used again. Now, for some people, yeah, Parliament is still supreme, right? Because they go back to the traditional notion of what Dicey has to say. Can Parliament still make or unmake any law? The answer is can. Can anyone question the validity of the Act of Parliament? The answer is cannot, including the courts, because the courts are not questioning the validity of the Act of Parliament. The courts are saying that the Act of Parliament is clear and valid. It's just that it cannot be used, that's all. And then thirdly, did Parliament bind its successors? This is the controversial part. There are some people that argue, of course, Lord Bridge is saying no. He has to. He's a judge, right? He's defending parliamentary supremacy. But a lot of academics, for example, Professor Wade, you can take a look at Wade's article after this. Professor Wade is saying Parliament is no longer supreme because he said something that was constitutionally impossible has happened. He says the 1972 Parliament, why 1972? The ECA 1972, right? He says the 1972 Parliament has now managed to bind all future parliaments. Has managed to bind all future parliaments. And so, because of that, Parliament is no longer supreme. Professor Wade says that. Do you agree with him? But many people disagree with Wade. For example, Allen. Now, Wade and Allen's arguments are in your notes. You just scroll down. I'm not going to read it with you. It's a long article, right? But you can read it, right? But Allen says, no. Allen says, no, Parliament is still supreme, right? Parliament is still supreme. Why do I say that? Why does Allen say that? He says, look, what the courts are doing is just interpretation. Interpretation is something that has been done for generations. Judges always take acts of Parliament and they interpret it to make it suitable. So now they are doing the same thing, except that they are interpreting it to make it suitable to the European Union laws. That's all. So Allen says, no, there's no revolution. Allen says Parliament is still absolutely supreme. What do you think? That's the issue here, right? In light of the UK's membership of the European Union, do you think Parliament is supreme or not? Now, this is my view. I'll share with you my view. You don't have to agree with me, right? And genuinely, this is an issue that will divide the class, will divide and has divided many people, right? So my view is Parliament is still supreme. Right? My view is Parliament is still supreme. Despite the factor tame decision, despite the McCarthy's decision, because I take parliamentary supremacy as a strictly legal discussion. And legally, can Parliament still make or unmake any law? Yes. Can anyone question the validity of an act of Parliament? No. Has Parliament bound its successors or be bound by its predecessors? Now, this is a trickier discussion. But my argument is, no, it has not bound its successors. Parliament is choosing to comply with its own act, which is the ECA 1972, isn't it? We are talking as if the ECA 1972 is someone else's law and Parliament is forced to follow. No, the ECA 1972 is an act of UK's Parliament. So the UK Parliament says, from now on, you follow. So we are following. If a time should come, and it did come, if a time should come when Parliament says, okay, fine, we don't want to be a member of the European Union anymore, we will leave the European Union, we will repeal the ECA. Can they do that? Yes, they can. And yes, they did. So that clearly shows that Parliament is still supreme. So my opinion is, not only is Parliament still supreme today, I think that one none of you can ignore. In light of the European Union, in light of the European Union, Parliament is still supreme because obviously the UK has left the European Union. But it is my opinion that during the time that they were a member of the European Union also, Parliament was supreme. Its supremacy did not stop. Its supremacy was not affected. Are we okay? Now, like I said, obviously, there are many people that disagree. If you choose to disagree with that opinion, which is perfectly fine, then you've got this guy. Read this guy. Wade. H.W.R. Wade. His argument, and I have summarized it for you, but his argument here is effectively Parliament is no longer supreme. Right? Okay, then today, the ECA 1972 has been repealed, as you definitely know. Today, there is the European Union Withdrawal Act 2018, as amended by the European Union Withdrawal Act 2020. And so the entire UK has left the European Union. So this entire issue of whether the UK is supreme or not in light of the European Union is a dead issue. Right? It is purely an academic issue. So if exam questions ask you that also, please make sure you are able to clearly tell the examiner that you know this is an academic discussion only, because the UK has already left the European Union 100%, clearly gone. Okay, ladies and gentlemen, that ends our chapter on parliamentary supremacy. And on that note, because we studied about the European Union, we are now going to go straight into the next chapter, which is the European Union, which is also part of these notes as well. Right? If you can see all of this here, all of this here. So now, the European Union chapter, ladies and gentlemen, the University of London has clarified. Now, if you pick up a textbook or you pick up some notes somewhere and you start reading, last time the European Union chapter had two parts. One of it was the European Union laws. We will understand how it works and all of that. The other one was the European Union institutions, meaning we have to learn about the European Parliament, the European Council, the European Commission, the European Court, right? And exam questions will come out on it. The University of London has made it very clear the institutions part is no longer part of your syllabus. The institutions part is no longer part of your syllabus, right? So that is why it's not even here in your notes, right? And if you look at the new updated version of your subject guide, by the way, guys, you may have realized that the University of London subject guides are no longer printed. Well, some of you are first time, so you don't know what I'm talking about, right? If you are older students, the university used to send you the subject guide. That means it's like their notes, right? It used to come physically. You guys won't get that anymore. Everything is on the student portal, right? So if you look at that, you will see that they have updated their syllabus, right? So guys, when you are studying, make sure you study after looking at the subject guide, because it is based on that subject guide that your exam questions are going to be set. Now, I'm not saying that the answer to the question is in the subject guide. That's not what I'm saying, right? So don't go back, oh, Daniel said, I just have to study this, can pass. And that's not what I'm saying. But they will lay down the syllabus for you so that you know exactly what to study, what you don't have to study. If it's not there, you don't have to worry about it. Okay, so I hope all of you have started looking into your student portal, because there's a lot of resources. I told you yesterday, right? And especially the subject guide. Now, the reason why they are not printing it and giving it to you, because now they have structured it in such a way where every chapter is separate, and after every chapter, there are some videos, there's some discussion, there's a forum, and they want your study to be interactive. See, last time they could just print out a whole book and send it to you because it's nothing, it's just notes. Now it is not only notes, it is, in fact, the notes have reduced. Now there are videos, there is, like I said, all kinds of good stuff there, right? Links. So if there's a case there, they will link you to the actual case that you can read and all of that. So please don't waste that wonderful resources, okay? So the point of me telling you that is, if you look at that also, there's no more institutions. So you don't have to worry about institutions anymore. Once again, this is not Daniel's opinion or Daniel's suggestion. The university has clarified this, so you don't have to worry about it. But what you do need to worry about is the European Union law part of the chapter. Okay, so exam questions can come They may ask you about the European Union in relation to parliamentary supremacy. That is what we have done the whole of today. Or they will ask you specifically about the European Union law and how it impacts the domestic member states. That is what we're going to do after this. So just because you see European Union in the exam question, it's not the same thing. Huh? You need to identify what exactly they are asking. In European Union, in relation to parliamentary supremacy, different type of question, different answer, obviously. The European Union laws on its own, different type of questions. Okay. What is the focus of what we're going to be learning for the next 2 hours, right? We will finish this entire thing in these 2 hours. Huh? What is the focus of what we're going to be learning? We are going to be learning about the different types of European Union laws. The European Union, ladies and gentlemen, is like I used this word earlier, it's a supranational organization. A supranational organization means it is an organization of countries. These are independent, sovereign countries. So the European Union, ladies and gentlemen, they have to deal, they have to be very delicate. Because countries are very sensitive people. Huh? They're not people, right? See, like Hong Kong doesn't need to care about your opinion when it passes a law. Do they ask you before passing a law? They don't, isn't it? They pass a law, and that's the law. Because you are an individual citizen, right? China doesn't have to ask you before passing a law. They don't care about your opinion. But the European Union is not dealing with citizens. No, so I don't mean to say only China. The UK also, when they pass a law, they don't ask individual citizens, are you okay with it? They don't. They pass the law and everybody follows. So when you're dealing with individual citizens, the government doesn't really have to care. But when you're dealing with countries, the organization above, they must have some kind of system where at the same time they want the same laws to apply around the European Union, but also they must give this feeling to the countries that they are still independent countries. Do you understand me? No? This is a difficult balance to achieve. See, the entire European Union, this project of this European Union will only make sense. This European Union project will only work if the same laws are applied everywhere in the European Union. If not, means it becomes a joke, right? Okay, Germany agrees to follow the rules, but Spain doesn't. UK doesn't want. Then in the end, then what is the point of having a union in that sense? The whole idea of a union is that all 28 countries must agree to the same laws. So the European Union needs to find a way to make sure that all the European Union countries follow the laws, apply the laws, but at the same time, the European Union needs to give them the illusion, and I use the word illusion, illusion that these countries are also independent and sovereign, so that they don't get angry and leave. So obviously they didn't do such a good job with the UK. Right? The UK got angry and left. Right? But yeah, so that is the context before what we are learning. So why am I explaining this context? Because I think it's important that you appreciate it. Because after this, when we are going to look at the European Union laws, you will find it to be very strange. Because, like I say, in the UK, right, we don't have different category of law, right? There's category 1, everybody must follow. Category 2, you follow if you want. Category 3, if you don't follow, so it's okay. Don't have, right? All laws must be followed, full stop. That makes sense to me. But in the European Union, you will find that there are different levels of laws. One law, all the countries must follow. Second law, they get to change it a little bit here and there. So you might be starting to ask, why? Why are you complicating the process unnecessarily? This is why. The reason is because the countries must not feel that they have lost Totally, they have lost all their independence and supremacy, and now some foreign body somewhere is making law for us. They cannot feel that way. They shouldn't feel that way. Right? So the focus of the next 2 hours is we are going to understand the different types of European Union legislation, the different types of European Union laws, and how it impacts the member countries. So the focus here is not just UK anymore. This is the entire European Union, right? So the focus is not just the UK anymore. This is the entire European Union. And we're going to see what are the mechanisms. How does the European Union ensure that its laws, the European Union laws, are applied across the entire European Union? How do they make sure that if a member state country doesn't want to follow, what can we do towards the member state? Right? So a member state is Germany, France, all the countries like used to be the UK as well. Are we good? Okay. So firstly, as far as the European Union is concerned, let's make this clear from the beginning. As far as the European Union is concerned, the European Union does not care about your internal problems. When I say internal problems, parliamentary supremacy is an example of an internal problem, isn't it? You see how much time we spent discussing parliamentary supremacy. Is parliament still supreme? Is parliament not supreme? Because internally in the UK, parliamentary supremacy is such an important thing. But that is UK's problem. From the perspective of the European Union does not care, because every country will have their own internal constitutional problems, isn't it? The European Union cannot be concerned about that. So, as far as the European Union is concerned, ladies and gentlemen, and this is seen in EU cases, this is seen in EU cases, for example, the case of Van Gen and Loos. The Van Gen and Loos case clearly tells us that if you have joined the European Union, you have limited your sovereign rights. You cannot come and claim as if you are still a sovereign nation. As far as the European Union is concerned, you have limited your sovereign rights. You have given up some of your sovereignty already. Can you see the disconnect? Right? And you see, the people in the UK, they know this. When you join the European Union, it's just like you join a club, right? Tomorrow you go and join a badminton club somewhere or a tennis club. And then you complain, why don't they play football in this tennis club? I'm upset, right? I want to bring reform to this tennis club so that we can play football. It's silly, isn't it? Because you join the tennis club, you must play by the rules of the tennis club. The same thing with the UK. They joined the European Union. They joined. And the truth is, the reality is, when you join a European Union like that, you are giving up some of your sovereignty. That's the reality of it. Again, now I'm talking from the point of view of the European Union. Yesterday and this morning, I was talking about from the point of view of the UK. Today, from the point of view of the European Union, all your little arguments in your countries are all rubbish arguments. The truth is, when you join the European Union, look at it, you have limited your sovereign rights. Look at the case of Costa. Again, these are all European Court of Justice cases. Costa says, the transfer by the states from their domestic legal system to the community legal system of their rights and obligations arising under the treaty, now this is the important part, carries with it a permanent limitation of their sovereign rights, against which a subsequent unilateral act incompatible with the concept of community law cannot prevail. Now, just because you see this now doesn't mean everything we did yesterday and this morning is wrong. I'm just telling you, this is the perspective of the European Union. As far as the European Union is concerned, when you join the European Union, you cannot now go and say, oh, but we cannot follow your laws because our parliament is supreme. As far as the European Union is concerned, that's a rubbish argument. You cannot use that. You join the European Union, you shut up and you follow our laws. Right? So this is the perspective of the European Union, right? So many cases are like that. So I'm not going to read them all, but they all say the same thing, right? The Simmenthal case, the Factor-Tame case, that went up to the European Court of the ECJ, right? All these cases are clearly telling us that as far as the EU is concerned, if they pass laws, they expect the member states to comply with it, full stop. Okay, now, let's try and understand what are these EU laws. So EU laws can be divided into primary sources and then secondary sources. Where's your secondary sources here? Let's talk about primary sources first. Okay, ladies and gentlemen. So firstly, you understand that the European Union is an international organization, right? And as an international organization, the European Union, right? As an international organization, the European Union is created by way of international treaties, right? All these various countries, they go around and they sign their treaties, right? So the big one is the Treaty of Rome, right? The Treaty of Rome is the main treaty that kind of created the European Union. Then after that, there are multiple treaties, right? By the way, you understand what a treaty is, right? When two countries sign a contract, you don't call it a contract. You call it a treaty. You and I, we sign a contract. But when two countries put down a few rules and they sign and they agree, it may not just be two, it can be 3, 4, 5, 28, 30, 500, whatever, right? They call it a treaty. Okay, so all the European countries got together and they signed the Treaty of Rome, and the Treaty of Rome is the treaty that sort of establishes the European Union. At that time, the European Community. And then after that, there were multiple other treaties as well. The Treaty of Nice, the Maastricht Treaty, the Lisbon Treaty, right? So many other treaties, right? All these treaties are put together in one document called the Treaty Articles, right? The Treaty Articles, right? So the name of that changes from time to time, right? So today it is known as the Treaties of the European Union and the Treaties for the European Union, right? There are these two. There's these two major sets of rules, right? Commonly, they are just known as the Treaty Articles. The Treaty Articles form the primary source of EU laws. You can say that the Treaty Articles is like the Constitution of the European Union. You shouldn't use that word, but I'm just giving it to you so that you can understand it, right? The Treaty Articles is similar to the Constitution of the European Union. That is why it is considered to be the primary source, right? The primary source of European Union laws. Because treaties are signed by the governments of the country themselves, right? So it is the most important laws are there. All your principles, your guiding principles, your free flow of trade, free flow of persons, all that will be laid down in the Treaty Articles, right? Treaties apply as soon as they come into force, right? So the main treaty was the Treaty of Rome, remember? The Treaty of Rome is the treaty that actually started it all off. But subsequently, many other treaties have been signed, and those treaties are always joining together. By the way, guys, you really don't have to worry about the article number 157, article number 405, whatever. The reason I tell you is because these numbers always run. Every time a new treaty is signed, they don't just add it at the back. What they do is they put it in the middle. So the number of those articles will run. So you will notice a lot of those articles, the number changes from 10 years ago. Today, the number has changed. So you, for public law purposes, you don't have to remember any particular treaty article with the article number 157 or article number 143. You don't have to. Now, in your second year, if you choose to do European Union law, then there's an entire subject on this, right? I will recommend that you only do that subject if you want to do the UK bar course. If you're not going to do the UK bar course, really don't do European Union. But that's my opinion. You ask the European Union lecturer, they will tell you it's so easy. But I never studied it. I never studied it. Just like I will say, public law, I don't understand. No need to even study. But a lot of people disagree with me. Right? For me, because I genuinely, even before studying law, I liked politics, how the government works, and all that. A lot of public law just clicked for me because I already enjoy reading about that. Who is the government? Who is part? The law part just is filling in the blanks. I already knew the big picture in my head already. Public law for me was the subject that no need to study. You know what I struggled with? Contract law. I hated it. For me, contract law just, so much to read, so much to... So, because public law is all just big ideas, right? Rule of law, separation of powers. What is it? Don't know. This is my opinion. I got a lot of opinions. So for me, that was easy. Contract, you cannot bluff with opinions, isn't it? Contract is offer, acceptance, consideration, intention to create legal relations. Offer, got 500 cases. Acceptance, 500 cases. All 500 cases are important. So my brain is not like that. I don't like it, right? But the point I'm making is, I think EU is difficult, right? Don't listen to me. You talk to your European Union lecturers, okay? Anyway, I didn't study EU also as a student, because I was never going to do the bar exam. My parents would never have been able to afford to send me to do the bar. I was never going to do the bar exam anyway. So European Union was never even an option. But anyway, for public law, what we are studying is just literally the tip of the iceberg, maybe like 5% of what is there in the entire European Union syllabus. It'll give you an idea whether you want to study it or not next year. All right. So anyway, coming back, the Treaty of Rome. Then you see all the other treaties came after that, right? The Treaty of Rome, 1957, the Maastricht Treaty, 1992, the Single European Act, 1986, Treaty of Amsterdam, Treaty of Nice, Treaty of Lisbon. All these subsequent treaties, ladies and gentlemen, were all consolidated. All the new things that were agreed upon by the countries in all the later treaties were put together, and they were always put together, and the whole thing is known as the treaty articles. Ladies and gentlemen, the treaty articles are, like I said, primary law of the European Union. The treaty articles are the primary laws of the European Union. Now, then what we have is secondary sources. Now, these are, so again, I told you the treaty articles is like the Constitution of the European Union. You shouldn't say it is the Constitution. I'm just drawing an analogy. It's like the Constitution. Regulations, directive decisions are like the laws in a country. This is passed by the parliament. This is passed by the government. Right? The treaty articles, parliament and all cannot change it. But they can pass laws like this. So there are three categories of laws, right? Regulations, directives, and decisions, right? Regulations, directives, and decision. So Article 288 of the treaty articles, they tell us what a regulation is, what a directive is, and what a decision is, right? They tell us this. Let's take a look at that. Right? A regulation, ladies and gentlemen, a regulation shall have general application. It shall be binding in its entirety, and directly applicable in all member states. Okay, let's understand that first, because there are some technical terms here. Look at this. Directly applicable. I explained to you earlier. Direct applicability means a particular law, if it is passed by the European Union, as far as the European Union is concerned, it immediately becomes law in the member states. Direct applicability means as far as the European Union is concerned, when a law is passed, it also automatically or immediately becomes law in the member states without any further intervention. So, if the European Union or the European Parliament or the European Council or Commission, they choose to pass a regulation, that regulation, number one, will be binding in its entirety. That means the member states, your France and Germany and England and so on and so forth. Well, not England anymore. Your member states cannot say that we don't want to follow this particular law. They don't have that option, right? It is binding and it has direct applicability in all member states. Ladies and gentlemen, if you remember this morning, this is exactly what the ECA was talking about. See, now you can piece it together, right? The ECA 2(1) is essentially the UK Parliament saying, as if they are the boss. Have you seen, do you have friends like this, or have you seen people like this? Their boss or whoever, someone in authority is telling them, you must do this. But they are people who are very proud people. They don't want to tell their friends, oh, other people are telling me what to do. So what do they go around telling their friends? I want to do this. That's what Parliament is, Parliament, or the UK government, effectively, in reality, they know that they have to follow what the European Union says. They know. But in the Act of Parliament, the ECA 1972, what do they say? They say, we are allowing the European Union. So any law that is passed by the European Union that is intended to be directly applicable, remember 2(1), will be given the force of law. So the UK Parliament is as if we are allowing it to happen. That is why it is happening. When the truth is, they have to, whether they like it or not. But the fact that they are allowing it to happen is the argument why Parliament is still supreme, right? Parliament is saying, we are allowing it to happen. But in the future, if we don't allow it to happen, then we won't. That's why we are still supreme. That's Parliament's argument, right? But remember, now we are not concerned with Parliament anymore. We are looking at it from the perspective of the European Union. As far as the European Union is concerned, if they pass a regulation, the regulation will automatically become law in all member states without any further intervention. Okay. If this is how the European Union is going to pass their laws all the time, I can imagine there'll be a lot of countries who will be upset. Not just England. Spain, Germany, Portugal, all these countries are countries that are proud, independent countries that have thousands of years of history. You think now suddenly they're all just going to be, oh, okay, European Union, you tell us to do, we will do it. So, although there is a regulation, there is also another category of law called a directive. This is, in my opinion, the way in which the European Union keeps the member states happy. Because a directive is different from a regulation. A directive is where the European Union Parliament gives the end result to be achieved to the member states. I repeat that. It gives the end result to be achieved to the member states, but how they achieve that end result is up to the member states. The member states can implement whatever local laws they want to suit their local situation, their local sensitivities, their local culture. But ultimately, that goal must be achieved. So let me give you an example. An example would be, let's say, if the European Union wants a reduction in carbon dioxide emissions by 30%. So the European Union is not going to tell you what to do. But the European Union says, we are giving you 5 years. And the end result, this is what you must achieve. But how you achieve it, that's up to you. So this at least gives some autonomy to the member states. The member states get to pass laws. The member states get to do whatever they need to do to suit their own culture, their own country, and do it in a way. So each country may have a different law that achieves that goal. Okay, so directives are different from regulations, right? So regulations are not binding as to how to do it, but they are just binding in the end result to be achieved. Okay, then you have what is known as a decision. Now, the decision is just like in the UK as well, isn't it? This is a decision of the ECJ. The ECJ is the European Court of Justice. So a decision of the European Court of Justice is binding, but it is binding on the parties before the court. Now, the European Union does not have a system of judicial precedent like the UK has. What is judicial precedent? Previous cases are binding on later cases. Right? That's the entire structure on which the entire UK's common law system is built on, right? Judicial precedent. Previous cases are binding on later cases. The European Union doesn't have a system of precedent like that. But a decision of the court is binding on the people that the decision is addressed to. So if two parties are before the court, one will be an individual, one will be a country usually, right? If two parties are before the court, the decision of the court is binding on the two parties. They have no choice. They have to follow. Okay? Lastly, there are recommendations and opinions. Now, this is not even categorized as law. When would you have a recommendation? When would you have an opinion? Sometimes, ladies and gentlemen, when a local court, the highest court of the land in the local country, they don't understand a European Union law. They don't understand the purpose of the law, or they don't understand how to apply the law. Because this is not UK laws, these are European Union laws. There's no guidance as to how to apply the law. The local courts, so again, the courts of Spain or Germany or UK, they can apply, or they can write to the European Union, the ECJ, and they can ask them for an opinion. They can ask them for a recommendation. And then the court will write the recommendation and send it back. In the meantime, the local case will be suspended for a while. Recommendations and opinions are not binding. Right? Recommendations and opinions are not binding. So, ladies and gentlemen, you can see that actually there are 5 different types of EU legislation. Although recommendations and opinions, people sometimes don't even call them legislation. But according to the treaty articles, there are 5 different types of levels of EU legislation. Right? Complicated, isn't it? In the UK, there's one, which is Act of Parliament. Right? Now, or case law also, because here if you count decisions, right? But this is why I told you earlier, it is important that it is like that. Because the European Union is not dealing with individual citizens. The European Union is dealing with sovereign, independent countries. There must be some leeway given to these countries. If not, means the countries are not going to be so excited to join the European Union. Right? Okay. Now, who passes these laws? The treaty articles No one passes. Only when there's a new treaty, all the countries sign it, then it is a new addition to the treaty articles. But what about the regulations and directives? Who passes regulations and directives? Well, the European Union has a very complicated, what's the word? Co-creation system. Right? So why do I say complicated? In the UK, let's say, for example, it's very simple. Who passes laws? Parliament. Full stop. Right? In the UK, in the European Union, things are a little bit different. The European Union Parliament, ladies and gentlemen, for a long time, is not like the parliament that we have in the UK. The European Union Parliament was actually a powerless body. Right? They used to call it a talk shop. People get elected, they go there, they sit there, they talk, debate. The best they can do is give a recommendation and then they go back home. That's it. But today that has changed. The European Union Parliament has increased power. So the three institutions, that's the word I should use, the three European institutions that are involved with lawmaking is the European Parliament, the European Council, and the European Commission. Very quickly, let me just explain to you what these three are. The European Parliament, I think you should understand, right? It is an elected body. That's the only elected body, European Union-wide. So members of the European Parliament, you stand for election. There'll be an election in England. There'll be an election in France, in all the other countries. You will elect your representative to the European Parliament. Each country will get a number of representatives according to their population. So the bigger countries get a bigger number of representatives, smaller countries get less. And then within the country itself will divide it. Okay? The European Parliament is the only democratically elected body. Right? What's the problem? I'll tell you the problem. Nobody cares about European election. In Europe, I don't know what is it like in Hong Kong. Do you all have a very high attendance for election? Does everybody go and vote? No? Okay. Actually, to be fair, that is a trend for most developed countries. In Europe and all of that, people don't care so much about their election. But even then, the number of people that go out to vote is usually 50%. It's not a lot, It's not a lot, but about 50% for their local elections. For the European elections, let me tell you, it drops down to 20-something%. Because people just don't care. Because they see the European Parliament as this far-away thing that nobody knows what's going on there. Nobody can understand what is going on, right? So they don't really care. So that's the European Parliament. What is the European Council? The European Council is an organization that is made up of ministers from every country. The ministers from every country. So if the council is talking about agriculture matters, the Minister of Agriculture from every country will sit in the council. If the council is talking about defense matters, the Minister of Defense from every country will sit in the council. Right? They also have the right to make law or initiate law, right? And lastly, the Commission. What is the Commission? Commission is interesting. Commission is a very powerful body. If you want to draw an analogy, they are like the civil servants, the senior civil servants of the European Union. Every country will send 2 full-time staff, not staff, 2 full-time commissioners. Now, this is a very senior position in the European Union. Very senior, very powerful. Every country will send 2, so there will be in total 50-something of them. These 50-something of them are like the most senior administrators of the European Union. They also have lawmaking powers, combined lawmaking powers. So the system now is the Commission can propose, Parliament can approve, or Parliament can propose, the Commission will approve. That kind of a system, right? A co-legislative system. Are we good? That's all you need to know. You don't need to go and research this any further, because remember, the institutions part has been taken away from your syllabus already. Okay, now, okay, now the next thing we're going to look at. So what have we learned so far? We've learned about primary legislation. We've learned about secondary legislation. You need to be able to explain. If an exam question comes out, you must be able to explain what the primary legislation is, what is secondary legislation, then secondary legislation, what is a regulation, what is a directive, the characteristics of regulation, the characteristics of directives, so on and so forth. Okay, then next, ladies and gentlemen, we are going to get into the issue of how does the European Union ensure that its laws are laws in the member state? How does it ensure that European Union laws are followed by the member states? Okay, now for this, ladies and gentlemen, I mean, it's all here in the notes, but I have written something as well that I want to refer to now. If you can take out one of the documents that I sent to you. It's called an answer guide to the European Union. Right? Okay. This document, if you have, I think I have laid it down a little bit in a little bit more simpler way. So we're going to follow this document. Same thing, Same thing. Remember, we started off by what are the primary sources of European Union laws? What are the secondary sources of European Union laws? We've explained what is a regulation, what is a directive, what is a decision, recommendation, all of those things. So the issue now is this: how does the ECJ ensure that community law has supremacy over the laws of member states? What are the mechanisms? What are the mechanisms that the European Court of Justice or the European Union, how do they ensure that their laws are supreme over domestic laws? They use three methods. Right? Three methods. And ladies and gentlemen, if an exam question comes out on European Union and you choose to do it, chances are this is what they will test you on. How? Number one, the concept of direct applicability and direct effect. Now, these are two separate terms, but in modern times, we have case law that have stated that direct applicability and direct effect, the difference between the two is too minimal. You don't have to worry about the difference, right? So direct effect and direct applicability can be used interchangeably, right? They mean the same thing as far as you are concerned. Are we okay? So direct effect is one of the methods. So what is it? And I've already told you, direct effect and direct applicability means that EU laws will have effect in the member states and citizens will be able to use them for their benefit. That means when the European Union passes a law and says it has direct effect, that means it automatically becomes law in the member states and the citizens can use it in their local courts. Now, regulations have direct effect. How do I know this? Because the treaty articles clearly say it. Remember, I told you the treaty articles, and we read this earlier. So the treaty articles clearly say regulations shall have general application. It shall be binding in its entirety and be directly applicable in all member states. So the treaty articles, the primary sources of law, already say regulations have direct effect. So no problems with that. But let me tell you why potentially this could be an issue. Regulations have direct effect, but the European Union does not issue regulations all the time. In fact, the majority of secondary law comes in the form of directives, not regulations. Can you understand why? For the same reason I told you earlier, if the European Union is seen as always passing regulations, then it's like they are forcing the countries to accept EU laws. The countries will get upset. Countries will get like, oh, they don't have any kind of independence anymore. And so then they will get upset. The majority, ladies and gentlemen, of European Union secondary laws come in the form of directives. So if the European Union passes a regulation, no problems. The regulation has direct effect. But what if the European Union passes a directive? What if the European Union passes a directive? Or even the treaty articles, the primary source of the European Union law. Do treaty articles and directives, do they have direct effect? This is an important question to ask. So if I am a citizen of, let's say, Germany, and I want to use a European Union directive in my local court, can I do so? The answer is, I can only do so if I have direct effect. If that law has direct effect. Okay? So let's look at when does a law have direct effect. So the case of Van Gen and Loos has given us sort of like a guidance. The case of Van Gen and Loos, the ECJ has held that if a treaty provision is to have direct applicability, it must, these are the requirements here. It must indicate that it applies not just to member states, but also to individuals within the state. That's number one. So it must be made clear that this law is intended to bind individuals also. Number two, it must be clear and precise. Number three, it must be unconditional and unqualified and not subject to any further measures on the part of the member state. Ladies and gentlemen, can I bring you back to your understanding of directives? What is a directive again? A directive is where the European Union gives you an end result to achieve, but how to achieve it is up to the member state, right? That seems to be going directly against the Van Gen and Loos requirement. Because the Van Gen and Loos requirement says, for a law to have direct effect, it must be unconditional, unqualified, and not subject to further changes by the member state, and no discretion given to the member states. That means according to Van Gen and Loos, which is an ECJ case, according to Van Gen and Loos, by the way, all our cases in this chapter are going to be a little bit strange. Strange only because we don't speak their language. You will see all the cases are going to be very long and in a different language. So the Van Gen and Loos case says that for you to have direct effect, there can be no more intervention by the member states. But the very definition of a directive is that there will be intervention by the member state. That means what? Directives don't have direct effect. If directives don't have direct effect, the meaning of that is directives cannot be used in the local court. And if that is the case, then, ladies and gentlemen, and as I told you, the majority of European Union laws come in the form of directives, then the majority of European Union laws cannot be used by the local guy, the ordinary guy in his local court. See, guys, I need you to understand this. This entire European Union project is not something that a lot of people understand. Yes, all high level politicians and technocrats and all of that are they understand and they appreciate the value of the European Union. But can you imagine just a regular farmer in Romania, or a factory worker in Bulgaria, or a guy who works in a pub in England? For him, this European Union is some concept that I don't know, I don't understand. It tells me that I get some benefits, but I don't see what are the benefits that I get. So then people are telling, no, the benefits is all these European Union laws. You can use it. You can use it for your benefit in your local court. So for him, in his understanding, that is the value of the European Union, because he doesn't understand these big macroeconomic principles. He doesn't understand trade barriers, tariffs, and all of that. He doesn't understand. He doesn't care. His job is serving beers in a pub. But if he can see, oh, the European Union, they passed this law is better than my local law, and I can use it in my local court, then for the common man, they are starting to see the value of the European Union. But ladies and gentlemen, if the majority of European Union laws cannot be enforced in the local courts, then for the common man, ladies and gentlemen, he cannot see what is the value of the European Union. It's just something that is all these famous and rich people, they talk about it. It's got no relevance to me. And if that happens, ladies and gentlemen, that entire European Union project will start falling apart. Because that's exactly what happened in England. The people in the European Union and the supporters of the European Union in England, they couldn't convince the common man that the European Union is necessary. They couldn't. He just couldn't see the value, the common man. He couldn't see the value. So he voted to leave. So why am I telling you all this? I want to tell you all this because you need to understand how important it is for the European Union to make sure that their laws are applicable in the domestic courts. Because it's even more irritating. Can you imagine yourself? Someone tells you, your lawyer tells you, oh, the European Union laws are going to help you, but you cannot use it in your domestic court. So what you must do is, you must go to your domestic court and you will lose. You still spend money, but you will lose. Then you finish the High Court, go to the Court of Appeal, you will lose. Spend the money, but you will lose. Then you go to the Supreme Court, you will lose again. But only after you finish the Supreme Court, only you can go to the European Court of Justice. You cannot go to the ECJ directly. Then you go to the ECJ, then you will win because the European law is on your side. Can you imagine how frustrating that will be to someone who already cannot afford to go to his local court? Now he is being told he has to pay at 3 levels and then go to Europe, which is even more expensive. Once again, so why am I telling you all this again? Because this is the struggle that the ECJ is facing. They must make sure that all their laws are applicable in the domestic courts. If not, means this entire European Union project will disintegrate. Okay, so this is the first problem that they are facing. For directives, it seems like directives don't have direct effect, according to the Wengen and Luce principle, right? Now, for treaty articles, the case of Hen and Darby versus the Director of Public Prosecutions, they confirmed that treaty articles will have direct effect. So treaty articles, no problems. But what about directives? Right? Now, directives, it was held that directives don't have direct effect. But ladies and gentlemen, the ECJ managed to pull some magic out in the case of Van Duyn against the Home Office. So let me tell you about this case. Van Duyn against the Home Office. Mrs. Van Duyn belongs to the Church of Scientology. Have you heard of that before? Scientology. It's I'm going to say religion, but some people say cult, some people say religion. What is the difference between a cult and a religion? A cult is a religion. A religion is a religion. A cult is a cult. 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 A cult is a right? I think number of followers, that's all, right? Scientology is famous because people like Brad Pitt and a few others, they're these famous Hollywood stars, they all belong to this Church of Scientology. Okay, anyway, in 1975, all these Hollywood stars hadn't joined them yet. They were seen as a cult, and they were seen as something that the UK government doesn't like. So Mrs. Van Dune is asking to come to the UK to work for the Church of Scientology in the UK. She is from Netherlands, right? She wants to come to the UK to work for the Church of Scientology. The UK Home Department said, no. Why? The reason for you coming is a reason that we don't like, so we're not going to allow you to come. So Mrs. Van Dune now is going to the European Court of Justice. And what is she saying? She's saying the UK government is stopping me from coming into the country purely because of their belief of the Scientology religion. This goes against European Community rules, the directive. This goes against the directive. Now, the problem is this. The UK government is saying, we don't have to comply with the directive in our local courts because a directive doesn't have direct effect, right? We don't have to comply with the directive in our local courts. And ladies and gentlemen, the ECJ was stuck because that is true. But you see, if they allow it, can you see how the entire thing will be rendered into a big joke? Because now so many of the directives cannot be applied. So what did the ECJ do? In the Van Dune case, the ECJ found, again, this is another cliche, right? They were thinking out of the box, right? They found an out-of-the-box solution. What they said was this. The ECJ held that since the directive laid down an obligation which was not subject to any exception or condition, it is by its nature did not require the intervention on the part of the community or member states. It followed that the directive was to be regarded as directly effective and conferred enforceable individual rights. What the ECJ did in Van Dune is they said, we shouldn't apply the blanket rule on all directives. We must take a look at each directive individually. Each directive individually must be looked at, because there might be some directives where there is no intervention needed by the member states. Because if you look at Wengen and Luce, Wengen and Luce says that there must be no intervention by the member states. Now, as a general rule, directives will require intervention, but there might be some directives where there's no need for any intervention by the member states. So the Van Dune case said, don't have a blanket application rule. Don't have a blanket application of where all directives cannot have direct effect. No, they said, look at each directive individually. Look at each directive individually, and if that directive is precise, is clear, and does not need any further intervention, that directive can have direct effect. Even though it's a directive, the directive can have direct effect. The case of Van Dune against Home Office said this. So the Van Dune case is now celebrated as one of those very creative cases where the ECJ has managed to go around a problem that they were facing. They were facing this problem that directives won't have direct effect. Now they've solved the problem by saying, look at each directive individually. Not every directive requires intervention by the member states, right? So directives today will also have direct effect. But if the directive is not precise, if it's not clearly defined, and if it requires a lot of intervention by the members, then it will not have direct effect. The case for that is Gibson versus East Riding of Yorkshire Council. Okay? Okay, summary. The first method by which the European Union ensures supremacy of EU law is the concept of direct effect. The concept of direct effect means when they pass the law, it becomes law, you can use it in your local court. However, this concept ran into a snag. There was a problem. What was the problem? Directives. There was a sudden legal issue. Do directives have direct effect? But this was solved by the ECJ in the Van Dune case. And the Van Dune case has confirmed that directives can have direct effect also. Are we good? Okay. Let's move to the second issue. Vertical and horizontal effect. Okay, anyway, time is 12:30 now. Huh? Let's take a short break. All right? Let's take a 10 minutes. We come back. We finish this. It's just a few more pages. And once we are done with that, we can go home. Are we okay? All right? Because we've completed what we need to complete today. But for now, let's take a quick break. Okay. Shall we continue? So the second issue or the second method by which the European Union tries and ensures that their laws are supreme over the domestic laws, and the way in which they do this is this concept of vertical effect and horizontal effect. So let me just draw this out to explain. So if this is the European Union, right? So under the European Union, you've got all the member states, right? So member states, member states, member states. So of course there are plenty, right? 27 of them now. And then in the member states, you've got citizens, the individuals that stay in the member states, right? Okay, now, it is the member states that sign the treaty to become a member of the European Union. The individuals, you and me, let's say, for example, in the particular country, they don't sign any particular, they don't sign a treaty to say that they also agree to be bound by European Union laws, isn't it? So this is a problem. So, ladies and gentlemen, if a citizen wants to sue his government, if the citizen wants to sue his government using a European Union law, a regulation or a directive or whatever, that is what we call vertical effect. Vertical, right? Up, down is vertical. If a citizen wants to sue the government, his government, because the government has done something wrong pertaining to or in relation to European Union laws, this is no problems. Why? Because the citizen, the government has agreed to be bound when the government signed the treaty articles. Now, the problem will arise when an individual citizen wants to sue another individual citizen using the European Union laws. The issue here is, can you make another citizen bound by European Union laws? Again, these are not the laws of that country. Because if it's the law of that country, then obviously every citizen is in compliance. But can an individual citizen use a European Union law to bring an action against another individual citizen? So the answer to that is very quickly no, right? The answer to that is no, right? You can see that here in the case has okay, let me just pull this down. Right? In the case of Marshall against Southampton and Southwest Hampshire Area Health Authority, it was held, right, that in principle, a directive could not of itself create obligations for non-state actors. What is a non-state actor? That means anyone who is not part of the government. Anyone who is not part of the government or anyone who is not part of an emanation of the government. So this was a problem, right? And let me give you a very real scenario why it is a problem. So let's say Mr. A works for the Ministry of Defense. Mr. B works for a government school. And Mr. C, he works in a private school. All three of them, let's say, have suffered some kind of abuse by their employer. So the employer for Mr. A is the Ministry of Defense. The second one is the government school. The third one is the private school, right? The problem is this: if A, B, and C, all three of them, want to use a European Union directive against their employer, Mr. A will have no problem because it is against the government. Mr. B will have no problems because a government school is considered to be an emanation of the government. But Mr. C, ladies and gentlemen, he's going to face a problem because the private school is considered to be an individual. Right? As you know, private companies are given their own separate legal entity. As far as the law is concerned, even though it's a company, if it's a private company, you have a separate private legal status as the company. Now, if this is the case, this is going to give rise to another problem. The same problem I told you earlier. Remember, the EU and the European Court of Justice are facing this problem that they need to make sure that their laws are equally applied for everyone to enjoy. But at the same time, it is true that you cannot bind a citizen. So the courts in the UK, the courts in Germany, the courts in France, even though they have to apply the European Union directive, the issue is they will apply it against the government. But against an individual citizen, there are many cases that say, sorry, you cannot. How did the ECJ overcome this problem? Right? How did the ECJ overcome this problem? Well, again, they came up with a very creative solution, right? So you see, this could give rise to the application of the European Union law in a non-uniform manner. So that is why I explained just now, Mr. A, B, and C, right? All three of them have suffered the exact same problem, but only A and B are going to get their remedy and C is not, right? So how did they solve this problem? They came up with this concept of indirect effect. This is where usually I will apologize to the students on behalf of the European Union. All the terms seem to be so similar. Direct effect, and then there's indirect effect. And then direct effect and directives, right? If you don't really understand it properly and you just vaguely remember, all these terms can tend to blend into each other, right? So direct effect, horizontal effect, vertical effect, indirect effect. Please make sure you know what all of these are and how they are different from each other. Okay, so this concept of indirect effect, what is happening here? Remember, what is the problem that the ECJ is trying to solve? The ECJ is trying to solve the problem of the laws that, although they may have direct effect, that means it's applicable in the local court, it only has vertical effect against the government, not horizontal effect against another citizen. So how do we solve that problem? The ECJ came up with the concept of indirect effect. So what does indirect effect mean? So even if you don't want to use the term indirect effect, some people call it the von Coulson principle, because it was invented by the ECJ in the von Coulson case. Von Coulson versus Land Nordrhein-Westfalen. I hope that's how to pronounce it. So what happened in this case? Right? The ECJ says, okay, fine. We cannot make a non-state actor bound. Right? And because the local governments and the local courts of the member states are saying, no, we cannot make a non-state actor bound, cannot. The ECJ jumped on this, Article 5. Today it is known as Article 10. This is Article 5 of the treaty articles. Now, you might be wondering, what is Article 5 all about? It actually has got nothing to do with the issue. But this is, like I said, a bit of a thinking out of the box, creative thinking type of solution to the problem. Article 5 says the member states and the courts have a duty to interpret national law in a way to ensure that its obligations to EU laws are achieved. Article 5 was generally just one of those generic articles that nobody pays attention to. Article 5 just says that all the member states must effectively do everything that they need to do to ensure that they don't defeat the intentions of the European Union. Article 5 says the member states must do everything that they need to do to ensure that the intentions of the European Union is not defeated. Although Article 5 has got nothing to do with the issue at hand, the courts jumped on that and they said, if you, the member states, if you do not enforce EU law even against an individual, if you don't enforce EU law against an individual, you are defeating the purpose of the European Union, and as such, you will be in violation of Article 5. Again, Article 5 has got nothing to do with the issue at hand, right? What is the issue at hand? The issue at hand is, can you use European Union law against another private citizen? And the answer is no, cannot. But the European Union says if the countries continue to say no, cannot, they will be in violation of Article 5. Article 5 is an article that says all member states must do whatever they can to ensure that the principles and objectives of the European Union are achieved. And so because of that, the member states and the member state courts now are forced to enforce EU laws against individual citizens. This is why it is called indirect effect. Yes, directly another individual citizen is not bound, but indirectly through this method, today individual citizens also can be brought to court under European Union laws that have direct effect. Okay, so this was laid down in the Von Coulson case, and ladies and gentlemen, in the Ma Li Sing case, this is another case, Ma Li Sing, no legislation had been passed to comply with the directive. However, the duty was nevertheless on the court to give effect to the Von Coulson principle. That is to say that the court must interpret domestic law in accordance with EU law. So the Ma Li Sing case was even worse. In the Ma Li Sing case, remember a directive? What is a directive? The European Union gives an end result to the country. The country is supposed to pass local law to comply with the end result. The country didn't do anything. 5 years has passed. This is Spain. Spain. 5 years had passed and the country didn't do anything. So now the issue was the citizen wants to use that directive against another private citizen. Because the local law is not there. The country failed in its obligation. The courts held, even though the country, Spain, did not pass the legislation needed, the citizen can use the European Union directive directly against another private citizen because of the Von Coulson principle. Because of the Von Coulson principle. So, ladies and gentlemen, this is another example of how the European Court of Justice has proven itself to be a dynamic institution, has proven itself to be a creative institution. Every time there are problems that it faces to ensure that its laws apply evenly everywhere, it manages to overcome these problems. These are the things that the examiner will want to see. You being able to explain how it overcame the problem, discuss the cases, you're good to go. Well, if you're doing this chapter. Right? The last method is state liability. What is state liability? Have you heard of this saying? You can either teach a donkey using a carrot or using a stick. So carrot is what? Positive reinforcement. Stick is what? Beat the donkey lah. If the donkey doesn't work, beat the donkey, right? So you can teach a donkey by using a carrot or using a stick. State liability is an example of the stick. In the sense that if the country does not do what they are supposed to do, if the country does not apply the law in the manner in which it is supposed to apply, then the states can be fined. There can be punishment against the state. So this is another way that the European Union ensures that all the states will follow. right? So they can punish the states, and punishment of, obviously you cannot put an entire country in jail. There's no European Union jail, of course, but it will be in the form of fines. It will be in the form of sanctions. In some extreme situations, it can be in the form of sanctions. Maybe this country cannot do business anymore or something like that, right? So in this case, there are these two cases here, right? The Brasserie versus Federal Republic of Germany, and the Crown against the Secretary of State for Transport ex parte Factor-10. We just learned this case today, right? Now, ladies and gentlemen, the Factor-10 case is interesting. There are 5 different cases. So whenever you want to refer to the case in the UK courts, that is Factor-10 number 2. So for parliamentary supremacy, you will refer to Factor-10 number 2. For the damages, for the sanction, you will refer to Factor-10 number 4. Because, ladies and gentlemen, in this particular case, the European Union fined the UK government for doing what they did. And it came down in Factor-10 number 4. But in these two cases, the ECJ said that the principles to regulate these damages, the principle to regulate the compensation, these are the principles. Number 1, when the national legislature, that means the parliament or the government or the judiciary, is responsible for the breach. So it's not just the government. If the courts don't want to enforce the European laws, they will be fined. Now you can understand why the UK judges and all, they always find creative ways to still enforce the European Union laws, even though it goes against parliamentary supremacy or whatever, right? Because they know if they don't, the entire country will be fined. Right? So if the breach is done by either the parliament or the government or the courts, that is the first criteria. Secondly, the rule of law breach is intended to confer rights on the individual. That means the European Union law was supposed to give some rights to the citizen, and that was the law that was breached. The breach is sufficiently serious, okay, that's enough. I mean, simple enough. And then there is a causal link between the breach of the obligation and the damage suffered. There is a causal link between the breach and the damage suffered. So you must prove because the parliament did this, you have suffered damage. Or you must prove because the court did this, you have suffered damage. Right? In that situation, ladies and gentlemen, then if all of these 4 requirements are satisfied, the state can be fined. The state can be forced to pay compensation to the citizen. Right? So a good example is the UK and in the Factor-10 case. Right? In the Factor-10 case, remember we just spoke about it earlier today, the Spanish fishing company. The UK government was forced to pay a large amount of compensation to Factor-10 because of this, right? So, ladies and gentlemen, this is how the European Union maintains supremacy of EU law over domestic law, right? This is how the European Union maintains supremacy of EU laws over domestic laws. These are the 3 methods. So once again, what are they? The concept of direct effect or direct applicability. Secondly, the indirect effect. Right? Remember the principle of indirect effect as was introduced in the von Coulson principle. And number 3, state sanctions. Right? So an exam question, if it is going to come out on this chapter, this is what they will be testing you on. How effective is the European Union in ensuring this? And you just need to, if you are able to reproduce this, again, as usual, build on it, do some reading, add on cases to that. But if you're able to reproduce this, ladies and gentlemen, you should be good to go. Right? Okay, ladies and gentlemen, so we have completed what we are supposed to do for this this entire weekend, right? The 3 chapters, rule of law, parliamentary supremacy, and European Union, right? So I will continue to remain here if you have any questions, but if you don't, we are effectively done, right? I'm letting you all go a little bit early, right? I have given you some sample answers for rule of law. Please read that, right? And of course, during the revision period, we will look at more questions and answers, right? So yeah, if you don't, I will be here until 1 o'clock. No, 1:30. I'll be here until 1:30 if you have any questions. But if you don't, ladies and gentlemen, thank you very much. I don't know when I'm seeing you next. Huh? I haven't seen my schedule. I don't think I'm seeing you physically anymore. At least I am not seeing you physically, but I'm quite sure I will be seeing you online. Definitely, I'm sure I'll be seeing you online at some point, right? So I will see you then. Right. Thank you very much.